I'm Karl Konrad and welcome to Australian Immigration News, your weekly updates to all that's happening in the world of Australian immigration. As this program airs, think of me relaxing on holiday in one of Australia's premier cities, the Gold Coast. This week, the Immigration Department made a few tweaks to the legislation that will start on the 29th of November. The two main items of changes are changes to the 186 legislation, and it will clarify the position relating to the work experience requirement for the TRT stream, and ensuring the Minister has the authority to cancel visas held by those who hold the SID 482 visa. Perhaps the tweak on the cancellation powers has something to do with this story about the neo-Nazi protester who had his 482 visa cancelled for lining up with his mates on the steps of the New South Wales Parliament House last weekend.
White supremacists dressed in black, their message even darker, demanding Jews and non-white immigrants be deported. But tonight, it's one of the neo-Nazis' leaders being thrown out. South African Matthew Gruter, his work visa cancelled.
If someone's intention is to tell Australian citizens that somehow they don't belong, that somehow they're not welcome, well, I'm sorry, mate, he's the one who can leave the country.
A pertinent reminder that those in Australia on temporary visas are guests in this country and should not bring attention to themselves for all the wrong reasons. The other change is to the 186 visa legislation, which relates to the requirements for the TRT stream. Recently, modifications to the temporary 482 work visa conditions were made, allowing visa holders to work anywhere they liked for a maximum of 6 months on 2 separate occasions. This has created confusion about which experience can be used to make up the 2-year work requirement, and also about the standards and pay rates in which this employment took place. There was a significant problem with the current legislation, which created a loophole that the department now wants to slam shut. The current legislation in Regulation 186.227 states, during the period of 3 years immediately before the application for the visa is made, the applicant was employed in an occupation, but the addition, as now going to say, was employed by an approved work sponsor in the occupation. And the other part of the legislation says during the period of 3 years immediately before the application is made, the applicant was employed in an occupation for a total period of at least 2 years. And again, the addition is was employed by an approved work sponsor. Now, this new law does not start until November 29, and the department's current information on their website says it allows work experience to be counted with a new employer as long as the nomination has been lodged, as the department's webpage indicates. If you have changed employers in the 3 years prior to your application, sponsored employment can be counted from the date an approved nomination was lodged if you started working with them before the nomination was approved. It is unclear what changes will occur to policy after this change takes place on the 29th, but the information provided in the explanatory statement makes it clear that the web page will probably be updated. When you take a read of the explanatory statement that went along with the legislation change, it makes it pretty clear. It states, the amendment regulations allow only sponsored employment on a eligible visa to count towards permanent residency requirements. This limits the right to work for applicants who cannot count non-sponsored employment as work experience for the purposes of the requirements of the ENS visa TRT stream. The wording cannot count non-sponsored employment pretty much seals it. It would be safer that if you intend to use the work experience time with a new employer, the sooner a new nomination has been lodged, the better. This legislation change has been made on purpose to try and make employees think twice before abandoning ship with their current employer. The explanatory statement is clear on this purpose. It states, this change incentivizes applicants to remain in the employment of their approved work sponsor and helps to ensure that the salary requirements and sponsorship obligations in the skilled visa programs apply to temporary skilled visa holders while they are working in Australia. What it doesn't say, of course, is that many employees have no option to leave due to business closures, etc. In this regard, the department is being very unfair to people who have already been forced to find a new job and sponsor. Let's see what the policies section has to say after this new amendment legislation begins. Finally, the department has released the details of all the state and territory sponsorship allocations for the 190 and 491 visas. You can find our comparison table here of the last few financial years, and this one that shows in particular last financial year to this financial year's allocations. Overall, the ACT has a 11% decrease, 28% decrease for New South Wales, 45% for South Australia, 31% for Tasmania, 32% for both WA and Victoria. Queensland had the most significant increase by a long way with a 116% jump, and the Northern Territory had a 32% rise. And why the Queensland jump, you say? Well, that was due to their own request last financial year, but the pressure to prepare for the Olympics now has put them under the gun. Overall, the total number is 21% fewer than last year. If you have a complex scenario related to any 482 visa situation, or indeed any visa situation, remember we are always here to help. You can book a consultation online, but if you're in a hurry, just pick up the phone and we'll see if we can squeeze you in earlier. Don't forget to hit that like button and subscribe if you haven't already done so. Next week we will have a special video about how visa refusals can affect your future applications to Australia. As always, take care out there and I'll see you next time. So bye for now.